Welcome, everyone, and thank you for joining us today for part 2 of this special 3-part series. My name is Michael Steinberger. I am founder and CEO of Jewish Heritage Alliance, a nonprofit platform dedicated to research, preserve, and most importantly, to promote the legacy of Sfarad. For those who may not know, the word Sepharad in Hebrew literally means Spain, but historically speaking, it refers to the Jews of the Iberian Peninsula, nowadays Spain and Portugal. And for those of you who are joining us for the first time, I'd like to point out that our mission is Sepharad specific, meaning there are many organizations that use the Sepharad term more broadly, often extending it to include Jewish communities from the Middle East, North Africa, and beyond. Our work deals specifically with the historical and cultural legacy of the Jews who lived in and were expelled from the Iberian Peninsula. To broaden our scope and expand our reach, we form strategic alliances with organizations, institutions, governments, and individuals across the public and private sectors that together create a voice of the collective, thereby amplifying our message. At this time, I would like to take a moment to acknowledge the partners that helped make today's presentation possible. I would like to thank the Sue and Leonard Miller Center for Contemporary Judaic Studies at the University of Miami for helping to co-sponsor today's event. I would also like to acknowledge, thank, and welcome 2 new co-hosting partners. We are excited to welcome Chabura, an educational organization dedicated to the theological dimension of Sfarad, making them a very interesting new partner. We are also excited and proud to welcome the Jewish Virtual Library as co-hosting partner. It's one of the most comprehensive online sources on Jewish history, culture, and current events. A hearty welcome to both. And of course, I would like to thank our shared hosting partners for their continued support in promoting our online events, and they are the Greater Miami Jewish Federation, the Center for Advancement of Jewish Education, also known as CAGE in Miami, the Museum of the Jewish People, the Society for Crypto-Judaic Studies, the Women's International Zionist Organization in Florida known as WITSO, and last but certainly not least, the European Jewish Community Center operating out of Brussels, Belgium. Thank you, one and all. And now, let's get started. At this time, it is my honor and pleasure to introduce today's moderator, a dear friend and colleague, Dr. Isaac Amon. Dr. Amon is the Director of Academic Research at Jewish Heritage Alliance and an attorney. He is also a lecturer at Washington University School of Law in St. Louis and was recently named a fellow at the London Center for Study of Contemporary Anti-Semitism. A grandson of Ashkenazi, Sephardi, and Mizrahi immigrants to the United States, Dr. Amon has served as a legal fellow at the International Criminal Tribunal for the former Yugoslavia in The Hague and as an ISIS war crimes investigator. He frequently speaks on law, anti-Semitism, and Jewish memory, with a particular focus on the Inquisition and the Holocaust. Take it away, Isaac.
Ladies and gentlemen, good morning, good afternoon, and good evening, wherever you may be. It is a pleasure to welcome you all to part 2 of our 3-part series, From Persecution to Renewal, the Sephardic Legacy and Foundations of Freedom. This series explores how the Sephardic Jewish experience, from forced conversion and exile to commercial ingenuity and constitutional ideals, shaped Jewish law identity and modern legal thought. Through a journey spanning the Iberian Peninsula, Amsterdam, the Ottoman Empire, and the early American Republic, we uncover how trauma, resilience, and intellectual exchange forged both Jewish and Western legal imagination, and how this legacy continues to influence the 21st century. As a reminder, in our first session, September 14th, moderated by Mr. Keith Stokes, Rabbi Dr. Yehonatan Elazar Demota examined the halakhic and ethical challenges faced by Iberian new Christians and rabbis as they sought to return to normative Jewish practice. Next month, on November 16th, we will explore how these experiences of forced conversion, inquisitorial repression, and transatlantic migration influenced foundational ideas about religious liberty in the United States. Today, in part 2, we turn to a remarkable story of renewal and creativity, the business law and practices of the Portuguese nation, the Nação, and Amsterdam and the Ottoman Empire during the 18th and 19th centuries. After periods of persecution, migration, and displacement, they built vibrant communities across Europe, the Mediterranean, and the New World. In Amsterdam, they embraced rabbinic Judaism for the first time in generations, constructing the stunning Asnoga synagogue and establishing a thriving mercantile center that linked Europe to the rest of the world. Others found refuge under Islamic rule in the Ottoman Empire, including the great cities of Salonika, Izmir, Istanbul, and Aleppo, the latter two of which were where my own paternal grandparents of blessed memory were born and lived until the mid-20th century. Bound by shared ancestry, a history of inquisitorial persecution, and trust in God and one another, these Homens de Nação, Hebrews of the Portuguese nation, created one of the earliest global trade networks. Guided by both halakhic principles and pragmatic commercial acumen, they built systems of contracts and ethical commerce that not only sustained Jewish commercial autonomy, but also contributed to the evolution of modern business law. Their legacy reminds us how memory of tyranny transformed into a culture of resilience, faith, and innovation. It is a special honor, therefore, to welcome back today our distinguished speaker from part one, Hacham Dr. Yehonatan Elazar Demota, a friend, colleague, and mentor. He was born in Miami and descends from a long line of Sephardic families from Spain, Portugal, and North Africa who established themselves in the Caribbean before migrating to the United States. He holds an MA in Anthropology and Religious Studies from Florida International University and a PhD in International Law from the University of Amsterdam. From 2020 to 21, he served as a visiting lecturer at the Universidad Lusofono de Porto in the Department of European Studies and Political Science. And from 2022 to 2024, he was a postdoctoral research fellow in the Political and Urban History departments at the University of Antwerp. He is currently a distinguished research fellow in the Law and Religion department at Emory University. And beyond academia, he has held numerous roles in Jewish communities across America, the Caribbean, and Europe. Lastly, he has published widely in Spanish, Portuguese, Hebrew, and English on Jewish law, philosophy, and Western Sephardic Jewry, making him uniquely suited to illuminate today's subject. Please join me in giving a very warm welcome to Hacham Dr. Yehonatan Elazar Demota as he presents Part 2, Nação Business Law and Practices, Amsterdam and the Ottoman Empire. Yehonatan, Hacham, Bechavod, the floor is yours.
Thank you, Isaac, for that presentation. And I would like to thank the organizers of this lecture series, the Jewish Heritage Alliance. It's a pleasure for me to be able to present the material that we're going to cover today. And I hope that you have many questions and we will address them at the end of our talk. I'm now going to share a presentation which I have prepared for today. We're going to be focusing on the 18th century and 19th century Nação, which established itself in the Dutch Republic, 17th century. This community was reconstructed from expulsion and then the Inquisition, or mid-Inquisition, I would say, which officially ended in 1834 in Spain and 1821 in Portugal and their territories. And what we want to look at today and explore are the business relationships between Jews who are in Amsterdam, the Dutch Republic, and those who are in the Ottoman Empire, who are trading with Jews and non-Jews. So we want to flesh out many of the ideas that emerged within halakha, Jewish law, and also in business, private international law at the time. So this research project was undertaken during the year 2023, during my studies of postdoctoral studies at the University of Antwerp. I came across various international legal scholars who talked about legal history. Martin Koskiemi, who is one of the leading scholars in international law, deals with the problem of Eurocentrism within international law. By this, it means that the writers or the legal historians who started to write the history of international law in the 19th century, most of them were staunch Protestants. With that said, This means that those histories that have to deal with minorities who are actors within the development of the theory of international law, they don't have voices. And that's something that appealed to me, because then at the same time, another legal historian, Asaf Likovsky, wrote an article entitled Legal Consciousness of Jews in International Law, and he asserts that the voice of Jews is not really heard in legal history of international law. And so this research project, what we're going to look at today, is the results of this theoretical framework. The methodology that I implement in this research has to do with archival analysis, legal anthropology, case studies analysis from law, and rabbinic legal analysis. So we're dealing with 4 different things at the same time. We're going to understand this here. I'm going to explain every step of the way. Before we get into our topic, we have to know a little bit about the Nação. If you were with us last time, you will have learned what the Nação is. The full term is a gente da nação, the people of the nation in Portuguese. The Nação emerged from or amid the Inquisition, and those Jews, those Iberian Jews, were able to leave the Iberian Peninsula and found their way into Western Europe, namely Italy, France, Germany, the Netherlands, and even Belgium, what we know as Belgium today. They established various communities in different places, and they created a business network, or I would say not created, but they continued the business networks which they had established already when they were in the Iberian Peninsula as conversos. This community, amid the ashes of the Inquisition, was able then to, with the help of rabbinic leaders coming from North Africa, from Italy, from Germany and Netherlands and abroad, as far as the Ottoman Empire, were able then to create an intellectual network or center for all Spanish Portuguese Jews around the world. Here's a map which details to the extent where these communities were established. In our last talk, we talked about the Caribbean context, South America, North America a little bit, and West Africa. And today, what I would like to do is to show how this community, despite having gone through so much persecution, so much travail, was able then to restructure itself from the Iberian context, now in the Dutch Republic context. I'm going to explain why that's special in just a minute. And then how they are then in the 17th century and 18th, 19th century able then to expand this business network to the Ottoman lands. Now, a little bit of history about what's happening between the Dutch and the Ottomans. There's a business relationship happening, but before business can happen, there are political relationships which are established first. In 1611, a Dutch envoy named Cornelius Haga was sent to Istanbul. He arrived in 1612 to negotiate a peace treaty with the Sultan. This then led, years later, 1625, to the establishment of the Directorate of the Levant Trade. This directorate was not a company, but a supervisory board of merchants called into existence with the support of the Dutch ambassador in Istanbul. Its main function or functions were to supervise ships' compliance with all existing legislation that regulated Mediterranean navigation, to control collection of maritime taxes, to verify ships' papers, and to maintain correspondence with the Dutch ambassador in Istanbul and the councils in the Levant and North Africa. The directors of the Levant trade also played an important role in setting up the playing field for Dutch councils later on. It drew up a list of nominees for consular appointments, set the council's salaries, and drafted their instructions, while the final political responsibility for the consulates remained with the States General. So States General in the Netherlands, the Dutch States General. And then we have between 1611 and 1625, we have the first Dutch consul sent to Aleppo in Syria, Niccolo Orlando, in 1618. In 1635, so after the establishment of the Directorate, the Levant trade, we have the first consul in Izmir in Turkey, Duca di Giovanni. Now, this time, what is important about this establishment is that there was a family, a Dutch family, which established a dynasty. And so the leaders of the councils in the Ottoman Empire this position was going to be transmitted from father to son for a number of generations from the 17th century to the 19th century. And this was held by the Hochpiet family, beginning with Daniel Jean de Hochpiet, 1657, 1723. What's very important to know about this is the consular protection of Jews. Without this protection, Jews will not be able to do business and trade between these countries. And the Dutch consul in Izmir in Turkey not only exercised authority as consul over the Dutch traders in the city and as vice consul over the variety of other merchants, he also took a number of other groups under his protection. The Dutch Levant trade relied to a great extent on Ottoman middlemen. So a lot of people who are working to make trade happen. By the mid-18th century, this group had come to include Armenians and Greeks, but a century later, these were, without exception, Portuguese Jews who had migrated to the Ottoman Empire. Here's one of the books which details this history for your records, if you're interested in pursuing more information. Here's another one, Inter-European Litigation in 18th Century Izmir, the Role of Merchants Style. And now let's analyze how the Ottomans administered their provinces, their territories. There were two terms, eyalet and sanyak. So pretty much, eyalet is like an entire province, and sanyak is let's say, a section, a subsection under the province, the eyalet. So here in this map, we can see in the 18th, 19th century, how the Ottoman Empire in this particular region was organized. We have the eyalet of Beirut, that's the entire section. We have the Sanyak of Tripoli in the north. And we have the Sanyak of Beirut and Sanyak of Acre and Sanyak of Nablus. And then in the south, the Sanyak of Jerusalem. So this is how the territories were administered for purposes of taxation. This research entails various sources. Among our primary sources, we have the Perid Es Haim Shailot Teshuvot literature. And what this is 12 volumes of cases which were dealt by the students of the Etz Haim seminary in Amsterdam. And these cases were actual real cases, but in order to preserve the identities of those individuals involved, we will oftentimes see other names such as Reuben and Simon, or Simon and Levi, Zebulon and Sachar, in order not to embarrass the parties involved in these cases. So these 12 volumes detail these questions which were raised to the rabbis and their students And we can learn about the legal nature and culture of this community through the questions and the way they responded to those questions. Another important resource, as primary source of this research, are the Portuguese Jewish communal archives in the municipal archives of Amsterdam. If you go to the library, the main library in Amsterdam, the municipal archives, you will find a section that houses the Portuguese Jewish communal archives. And these archives gives us a lot of information about how the community was structured, what were their haskamot, and the culture of the community from a political and legal nature. Now we have another resource, Talmud Torah Chaim, Livro de Citações e Resoluções, 1717 to 1816. So this is about 100 years. And this resource is extremely important because what we find here are cases where business partners or business partnerships were undertaken by members of the community, and they went before the Ma'amat, or members of the Ma'amat, or the Bet Din of the community, the Jewish court of the community, in order to make an oath that they were going to fulfill contractual obligations according to the Shulchan Aruch. So that's the legal code, which was codified or prepared by Rabbi Yosef Karo in the 16th century. And the Livraria de Montesinos, which is in Amsterdam, part of the Portuguese Jewish community, has books that go back to the 13th century. The oldest book there is a Mishneh Torah, which was found in France from the 13th century. And there are many books that came from Italy in the 15th and 16th centuries. And all of the books, the halakhic and legal codes, which were written by the rabbis of this community and other communities in Morocco and North Africa and the Ottoman Empire. So it has two levels. The lower level has those books which were before 19th century, and then the second level has the books of the 19th century and into the modern time period. Something that's very striking, well, I wouldn't say striking, but is very different from this time period, wherein Jews have rights. If we go to the political context of Jews in Europe at the time when Portuguese Jews are establishing this Nação community in Amsterdam, Jews are not accepted pretty much nowhere in Europe. We can read the writings of various political leaders, such as Jean Baudin in France or James Harrington in England, and many others who compare Jews to be like a limb that doesn't fit on a body, or anathema against the Catholic or Christian worldview. And this creates a problem for how European Christians are going to treat Jews or handle Jews. And amazingly, within this context, we have this Protestant country or Protestant territory, the Dutch Republic, which receives Jews. And not only that, Jews in the Netherlands, specifically in Amsterdam, were given political religious autonomy with some caveats, but this is very amazing because they were able to rule. Portuguese Jews were able to decide cases, civil cases, religious cases, according to halakha, according to Jewish law, within this context. The same thing is happening in the Ottoman Empire context in North Africa, in the MENA lands. Jews have political religious autonomy. And so this makes the Dutch Republic an extraordinary case. And this is why I believe one of the reasons why many Jews flocked to Amsterdam as a new Jerusalem, because there was a place where there was a lot of wealth and Jews were able to flourish financially. So when we look at the structure of the halakha, we have the Talmud, which is the basis of all Jewish law. Then we have the period at the close of the Talmud, the Geonim, who decide various matters which are not clear within the Talmudic literature. And then the codification of Maimonides, Moses Maimonides, the Rambam, in the Mishnah Torah, in 14 books. And then in the 16th century, we have Yosef Karo, who prepares a Shulchan Aruch, or Bet Yosef and Shulchan Aruch, and simplifies the halakha in a more practical term. Within the Portuguese Jewish community, there were two, let's say, leading institutions. We have the Ma'amat, which was a group of wealthy elites of 7 members, and we have the Bet Din. The Bet Din had a minimum of 3 chachamim, 3 rabbis. One of those rabbis led all the religious aspects, or the liturgical aspects of the community. Another rabbi facilitated all of the ritual functions in terms of burial and cemetery and those records. And another rabbi was the leader of the tribunal and of the rabbinic school to train new generations of rabbis. And the Ma'amat is a very important institution in the Portuguese Jewish community, which Amsterdam Jews copied from the Italian context, from the community in Venice. And the Ma'amat was actually the brain of this community. Many times rabbis were in disagreement with the Ma'amat, but because they were salaried, they had to listen to what the Ma'amat told them to do. Now, in our cases in the archives, what we find is that those members of the community that wanted to do business according to the laws of the Shulchan Aruch, they will go before 2 members of the Ma'amat. According to halakha, you need 2 witnesses, and they would put their hands on a Sefer Torah, on a scroll, Torah scroll, or a holy book representing the Torah, and then they would swear, make an oath in the form, they would make a swearing that they would follow those stipulations in business law according to halakha. This is very interesting that this is happening because they have this political religious autonomy to be able to do this in Amsterdam. And what we find in the archives many times is that if members of the community went to the civil Dutch courts with their cases with members from the same community, the Dutch civil courts will go to the Portuguese Jewish community and ask them for advice and ask them to even rule on those cases. So there we see a collaboration of how that's happening in the Dutch context. The Etz Chaim seminary, as in the 18th century, 19th century, was spearheaded by 2 Chachamim, Yitzhak Chaim Abedana de Brito and David Cohen de Acevedo. And they had their students, respective students, Yitzhak ben Shlomo Saruco, David ben Rafael Mendola, and Shemuel Mendes de Sola. And I highlighted these students because the cases that I would like to analyze today were written by these 3 students under the supervision of the 2 Chachamim, Abedana de Brito and Cohen de Acevedo. And what we're going to look at in these cases that have to deal with relations between the Dutch Republic and the Ottoman Empire, we're going to understand how Portuguese Jews contribute to the development of private international law at the time, and how they're dealing with with secular law and how religious law or Jewish law is going to conform to that law or vice versa. So this is something that's very interesting at the time, because Jews are active participants in this trade and in this development. But because there are Jews, they're not recorded in the legal history. And that's what I'm doing with this research, giving them a voice. Our first case is 1752 in the Eyalet of Egypt. So we go back to our map, we can see the Eyalet of Egypt. It's in the southern left corner, the left bottom corner. So that's the Eyalet of Egypt. So this case, the Eyalet of Egypt, we have two people, Reuben and Shimeon. Of course, these are not their names, but we're utilizing these terms in order not to embarrass them. And the case goes as follows. Reuben lives in Amsterdam while Shimeon lives in Egypt. Reuben assigns a power of attorney to Shimeon so that he can sell all the peppers that he sends him by sea. So Reuben is in Amsterdam and Shimeon is in Egypt, and he's sending him peppers, bell peppers, by sea. Reuben tells him to sell everything and send back the profits. Unfortunately, the ship suffered bad weather and could not reach destination in the allotted time for Shimeon to sell the peppers. After the passing of time for the business, Reuben claims that Shimeon did not fulfill his power of attorney. Shimeon sends Reuben wax in return for the loss of the peppers. However, Reuben demands that Shimeon send him the peppers, even though it's not his fault that they were damaged. This question was brought forth to the judge, Isaac Haima Bedana de Brito. So this responsa first distinguishes between a partnership of the agent. We can see here on the right side, this is a picture of the actual case as it was written. This script is Kitab Sephardi, or Sephardic script. Some people know it as Kitab Rashi, the Rashi script. And you can see the sections first on the right, upper right, says She'elah, that's the question, and then beneath that, Teshubah, the response. And it comes with various sections. And this responsa distinguishes between a partnership, and an agent. The agent does not have the same responsibility as a business partner. This is the case, and the case of force majeure. That means when there's a natural act, or in law today it's called acts of God or acts of nature. And so in halakha, this is called onesut, or in the state of onesut is someone that's anus, the plural being anusim. And the question here is, does the agent have to pay for the loss due to force majeure or not? According to halakha, the agent does not have to pay for the loss, or the agent does not have to pay for the loss due to force majeure. However, if the agent makes any changes to the stipulations of his or her power of attorney without permission of the principal or grantor, it is canceled. So that no changes can be made to this. As we see in this case, the agent will be held responsible even if he or she suffered force majeure due to natural causes. So the verdict in this case, at the end, the conclusion is that the case was judged in favor of Reuben, who is the one who sends the peppers from Amsterdam. Because Shimeon made changes to the terms of his power of attorney, despite the loss at sea from natural causes. The fact that he sends wax, which was in his possession, he intended to enrich himself instead of returning the damaged peppers to Reuben. Therefore, he was held responsible for paying the value of all the peppers. So we learn from this case how to deal with force majeure and power of attorney in halakha, and then how this is translated into the law of the land, or the legal terminology in Jewish law, dinan de malchuta dinah. The law of the land is law in financial matters. Then brings us to case number 2. Case number 2, in 1767, in the Sanyak of Acre. So that's, if you know a little bit about the map today of Israel, that is in the north of Israel. very close to Haifa and the border of Lebanon. So again, we have another two people here involved, and we're calling them Reuben and Shimeon. We have the question and the response. And this case is very interesting because it was answered by David de Rafael Mendola, and it deals with slavery and slave trade, which was something very normal at the time. Reuben lives in Sipori and owns a Canaanite maidservant. He brought her according to the law of the land. After a time, she expresses to her master to free her so that she can become a Jewess. We have spoken about in the past how, according to Jewish law, when Jews purchase slaves, they undergo a number of rituals. If it's a male slave, the male will be circumcised and then undergoes a ritual bath. And then after 12 months, if that slave wants to join the Jewish people voluntarily, then he will undergo a second immersion and then be a full-fledged Jew, and he will be freed from his slavery, his slave status, and will join the Jewish people. In the case of a woman, she undergoes the two ritual baths or immersions, one at the beginning of her service and the other at the end of the service. And so this is what refers to Ebed Kenani, or Canaanite servant or maid servant in Jewish law. So in this case, Reuben lives in Sipori. He owns a Canaanite maidservant. He brought her according to the law of the land. After a time, she expresses to her master to free her so that she could become a Jewess. So she wants to voluntarily become a Jewess. Due to the difficulties with this, he sends her away as a gift to a relative who lives in Tiberias. So those of us who know where Tiberias is today, in the land of Israel, it's bordering the Sea of Galilee, or the Sea of the Kinneret. So from Sipori to Tiberias. And due to the difficulties with this, Reuben sends her to his relative, Shimeon, in Tiberias. He sends her with a note stipulating that he take care of the details to free her according to the law, meaning Jewish law, making her a Jewess. Reuben expresses that he has full trust in Shimeon that he will do this on his behalf. Upon receiving the letter, the brother replies, I don't know if you heard, but one who frees his or her slaves violates a positive precept from the Torah. You shall make them serve you forever. Leviticus 25. So Shimeon replies to Reuben with the legal convention that he understands and accepts at the time, that slaves are not freed at that time. He continues saying that the manumission of slaves does not apply at the present moment, therefore he desists. Reuben replies and tells him that since he does not want to violate a positive precept of the Torah, he will repeal the gift, so he should send the slave back. Reuben then sold her to Levi, his beloved friend who lives in Tiberias, and gave her as a gift. Since Shimeon knows the scriptures, he thought to return the slave to Reuben, but Reuben had already decided to give her to Levi instead. How was he allowed to do so, being that he had not received the gift in return? So this is a question of ownership, gifts, ownership, possession, and Canaanite slavery. It's unfortunate that we have to talk about this topic at the time, but this was real at the time. This responsa cites the Talmudic notion of receiving gifts. Once a gift has been endowed, even if the recipient hasn't received it, it is considered mekubal, received. The giver no longer has possession of the gift. The receiver can choose whether to receive or to return. As such, the giver cannot change his or her mind afterwards. In the same vein, the receiver cannot change his mind until he has possession of the gift. So the verdict here, David de Mendola says, or de Rafael Mendola says that the case was judged in favor of Reuben. Since Shimeon never received the gift, he didn't accept the stipulation in Reuben's letter to free the slave. Therefore, the ownership was in the hands of Reuben. Accordingly, he could do as he pleased with her. So Reuben could send this slave woman to his other brother in Tiberias named Levi. So this is what we learned from this case, how gifts, ownership, possession, and slavery were dealt with within the Ottoman Empire. In our final case, in 1803, in the Eyalet of Sidon, and we know the Eyalet of Sidon is far north in the lands of today, what is known as the country of Lebanon. We have two Jews, and this responsa calls them Issachar and Zebulun. If anyone here knows, Issachar and Zebulun are two tribes of the 12 tribes of Israel, and specifically in rabbinic tradition, Issachar and Zebulun represents a type of partnership where Issachar dedicates to the study of the Torah or intellectual pursuits, and Zebulun dedicates his life to financial pursuits, and then donates his funds in this partnership to Issachar to be able to study the Torah. And so this type of partnership then enables both to grow intellectually and financially. So in this case, in the Eyalet of Sidon, which is today modern-day Lebanon, we have Chacham Kohen, David Kohen de Acevedo, and Issachar sends his merchandise to Zebulun from the city of Sidon to sell them in his city, and he sends him the profits. Zebulun sold the merchandise and made profits, but did not send the records of sales nor the profits to Issachar. Zebulun mistreated the money of his partner. Issachar went to Sidon and saw that Zebulun was a wealthy man, renowned by all. Everyone there knew that Zebulun had enriched himself through Issachar's investments. Now Issachar files a lawsuit against Zebulun for him to return the profits and the investments of his merchandise. What is the verdict of this case? This case is very interesting because what's happening here is we have a Jew who is in Sidon, and we have another one who is in another land. And this case reaches Amsterdam. So we have a tribunal in Amsterdam overseeing a case that is happening in the Ottoman Empire. And this is interesting because in law, we talk about jurisdiction. In Jewish law, the jurisdiction is universal. It's international. So that means that a court in one place can judge a case that is in another place. It doesn't have to be there. Very different from how things are done today, wherein one rabbinic court has jurisdiction in one place and another court in another place. In this time period, we see how the borders don't exist in terms of jurisdiction in Jewish law. And so this response establishes the difference between business partnerships and power of attorney to determine which is the case at hand. In a business partnership, it is prohibited for an individual to utilize any principle of the investment without knowledge of the investor. This constitutes two thefts. An agent, however, has more autonomy to make financial investments. Also, in the case of a business partnership, the partner who takes actions in business is liable to giving a share in the profits to the investor. So here, what the judge is looking at and determining is whether this is a business partnership or whether this is a grantor-agent relationship. And the verdict, which was given by David Cohen de Acevedo, was that the case was judged in favor of Issachar. It was decided that this was a business venture and that Zebulun did not do honest business with Issachar. As such, he must pay 50% of the profit that he gained from Issachar's investments, especially because everyone in Sidon knew that Zebulun enriched himself with Issachar's money. So there are many witnesses to attest to this fact. So in this case, we learn about business partnerships. power of attorney again, and investments and profits. So, as a matter of conclusion, these are some things that we learn from these cases and this context. Jews are able to engage in international trade through contractual agreements according to the halakha. That's very interesting because non-Jews are doing business according to all of the agreements, maritime law, and business practices which were established by the law of nations, or jus gentium at that time, which then became to be known as international law. But Jews are doing business with each other across various borders according to the laws of halakha. So coming from the Talmud, Mishneh Torah, and the Shulchan Aruch. And halakhic business law is based on trust and goodwill. This is something that's very profound, and this goes back to the concept of berit, which we talked about last time, the notion of a covenant, a blood covenant between brothers. The fact that we have two Israelites, two Jews who share the same covenant, there is an understood idea of trust and goodwill because we come from the same covenant, that we're not going to have bad blood or bad business. We're not going to treat each other in a bad way. So all of this entire corpus of business law assumes that there is trust. It gives what we call hazakah, legal presumption that there's trust and goodwill, and that business partners are not going to damage one another and break trust. And also, as we said earlier, although jurisdiction is flexible, the Amsterdam Bet Din is presiding. We see how in all these cases that are happening in the Ottoman Empire, they are brought to Amsterdam as a center. And so the judges of the Amsterdam Portuguese community are presiding on these matters. And finally, we have political religious autonomy for Jews in Amsterdam and the Ottoman Empire for self-governance, which is extraordinary for the time. And all of this convention ends when Napoleon Bonaparte emancipates the Jews at the end of the 18th century. And what we see happening is that all of these civil laws and conventions, according to Jewish law, become secondary, and the Jewish tradition becomes based more on ritual law. And so then it is possible then to talk about Judaism as a religion, as opposed to a political legal consciousness. Thank you for your time. Now we will hand it over to Michael.
Wow. First of all, thank you, Jonathan. Thank you for another mesmerizing, amazing discussion, this time obviously embracing the Portuguese nation, or the Nação. Especially how they created self-governing global communities that embraced halakha, commerce, and law. And thank you for your continued commitment and dedication to preserving this legacy. Before we continue, at this time, I would like to take a quick moment and make a special appeal. As you know, Jewish Heritage Alliance is a nonprofit. We are a nonprofit organization dedicated to preserving and promoting the Sephardic legacy. So one of the many ways in which we fulfill this mission is by offering these free webinar events. Now, while they're free to attend, they're certainly not free to produce. So at this time, I'd like to ask you, our dedicated audience, to please get involved, support our effort, consider making a tax-deductible donation that will help us and will support, the work of today and always. Just before we go into the Q&A, I also want to mention about our very special and unique tour programs, which are designed, they're intended to bring the stories of Sfarad to life. Those of you who are interested, please contact us for more details. And so at this time, I would like to turn the program back over to Isaac and Jonathan They will address some of your questions. The questions that we are not able to get to, we will email to you the answers for them. And also, we remind you that actually, I'll ask Isaac to remind everyone we have the third part of the series coming up next month. And I guess Isaac will talk about that as well. So I now turn it over to Isaac and Jonathan. Thank you.
Thank you, Michael. Jonathan, as always, very fascinating, brilliant presentation overview, something that, of course, I find particularly interesting because I have a legal background and a lawyer and teach in a law school too. So let's see, we have a number of questions that I've tried to group into, relevant categories here. But first of all, I'd like to ask us some, before we even get into that, there are some questions about any books you may have written. If people want to purchase your own publications or writings, where's the best way or website or way to do that?
I will put it in the link in the chat right now. So it's my website, bmlazar.org. There's a section there on books, publications. So if people want to read my articles or my books, purchase, follow videos, everything is there. All my intellectual work is on the website. So that's in the chat. Yeah.
Okay, great. Thank you very much. So let's go back in the beginning to, you mentioned, of course, the Ma'amad. You mentioned its relationship to the Beit Din. So one question we have that goes into a second one is, again, how did these Jewish communal structures, such as the Ma'amad, intersect with guilds or state regulation in both regions, Amsterdam, the Ottoman Empire? I mean, you touched on it, and geographic context. And a secondary question that I think is related is there a perception, at least by some people, the Ma'amad was at times dictatorial and abusive of constituents? And how was that seen by the Beit Din and the larger community?
So we have two questions here. One is about guilds, the Ma'amad in Amsterdam, and the second one is about the relationship between the Ma'amad and members of the community, especially with the rabbis. So with the first question, in the 17th century, we have the Portuguese Jews were not, in order to be part of the guilds and the stock exchange and trading, they had to have what's called porterschap, which is like citizenship and to have the rights. But Jews cannot have porterschap in the Netherlands, 17th century. But there were exceptions to the rule because there were some elite members who were allowed to partake in the guilds. And a lot of this trade that's happening is now only Jews. We have Jews and non-Jews working together. So you have Jews who may be creditors, and then non-Jews own the ships. The captain of the crew are non-Jews, and they're taking merchandise owned by Jews to the Ottoman Empire. So it's a collective collaboration. This is what's happening. But the business, at the end of the business, we have a Jew here trading with another Jew in the Ottoman Empire and vice versa. So that's our first question. Second question is very interesting because when we look at the history of this relationship of the Ma'amad and members of the community, a lot of, depending on which book we're reading, we can see how a particular historian would say that the Ma'amad was monolithic, that it was too rigid. We can see certain cases, for example, in the case of Menashe ben Israel, who wanted to publish a book named Conciliatur, which reconciles many theological, let's say, discrepancies or texts within the Hebrew Bible. And he published this book. He wanted to publish it, but the Ma'amad did not give him permission to do so. And if you didn't have permission to publish a book, you couldn't do it. And if you did it, you would be excommunicated or you would be censured. And so Menashe ben Israel really wanted to publish this book. And what he did was he had it published in Franeker in Germany. So it was a controversial book because it was written in Latin. And Latin, as you know, is the language of theology at the time. And what it did was it allowed non-Jews to have access to Jewish intellectual property, which then could create problems for the community. Amsterdam Portuguese Jews wanted to be low-key. They wanted to integrate as much as possible into society and not talk religion on the streets with anyone. And only certain Chachamim were allowed to engage in theological discussions with persons outside of the community. That was one of the biggest problems that Spinoza had, and others as Del Prado and Uriel da Costa. They spoke without permission to the locals and created problems then for the community. So this is a case. This is one example of how the Ma'amad was very. I don't like to use those terms like abusive, but I would say that the Ma'amad had a vision as how they wanted to rule this community, and we could say that they were very rigid in some cases. They were very rigid. One of those another case where we can see things were rigid was how they dealt with the issue of circumcision. There were many members coming between Spain and Portugal, back and forth into the Dutch Republic, and they didn't want to circumcise themselves, because if they will be caught by the Inquisitors, the first thing will be drop your pants, and they will know that they are Jews. That would be a problem. So the Ma'amad, under the direction of Chacham Saud Levi Morteira, made a ruling that anyone that wanted to be a member, like a full-fledged member in the community, had to be circumcised. And many of them did not circumcise themselves because they were going back and forth as merchants. So they had multiple identities. They were acting as Jews in Amsterdam and then acting as non-Jews when they went back to the Iberian Peninsula and elsewhere within the territories of Spain and Portugal in the New World. So these are some cases where there are many others. There are many books written by this. I think Daniel Swetsky, I'm not sure how to pronounce his surname. Miriam Bodian also speaks about the Ma'amad and the structure and how it dealt with the community. There are various books that deal with this. But as I said, depending on the historian and the background or the perspective of the historian, we will then see how they kind of interject their own emotion or opinion into the history. So I try to stay away from that.
Yeah, no, that's great. I think we're all products of the time and place in which we live. And
Right.
in terms of resolving mercantile disputes, this kind of fascinating interplay between different legal traditions or families or legal pluralism. We have a question. And again, it's probably two-part here, but did Portuguese Jews ever resolve intra-Jewish disputes before civil courts, or did they keep it solely, within the Beit Din? And then if it involved a dispute, of course, between a Jew and a non-Jew, what tribunal would preside?
That's a very good question. Yes. One of my colleagues, she's at Ghent University, I believe, or no, is it Ghent University? I think she's at Ghent University. She's specifically researching this. Her surname is Mormon. Manon Mormon. She does research on in 18th, 19th century Portuguese Jews and how they did business outside of the Ma'amad or outside of the Portuguese Jewish religious structure. So they would go sometimes to the local Dutch notary. And so one of the questions that emerges from the archives is, why would Jews prefer to go to the civil courts and not the Jewish court to do business? Right. That's a big question mark. I even have that question. Why would they prefer to do that? And so that's one thing. And then we have cases where there are Jews and non-Jews doing business. As I said earlier, these types of international trade involve many different peoples, many actors. And so if there was a default, let's say a breach of contract, these cases will then fall under the jurisdiction, not of the Jewish court, but of the local courts. And there were different maritime courts in different places in France, in Ottoman Empire, North Africa. And so those courts would then have jurisdiction over those cases, not the Jewish courts.
Okay, so that makes sense. That's fascinating. You talked about the universalism, the internationalism of rabbinic jurisdiction up until at least the age of emancipation, right? It seems. So here's a question: is the universalism of the rabbinic decision making was that limited to Sephardic communities and the Nação, or did it also include Ashkenazi Jews, Jewish
There
communities?
are Ashkenazi Jews involved. In the archives, I've seen the archives in the 19th century. There are many Ashkenazi Jews in Amsterdam and Germany who are trading with Portuguese Jews. So it's not only happening among Sephardic Jews. Yeah.
Okay, very interesting. Were there any differences at all? Again, you talked about that they took the jurisdiction of the Amsterdam Pateen even into the Ottoman Empire. The communities accepted it. But of any Ottoman decisions, which you did mention, are there any differences in business ethics discourse or rulings between Amsterdam responsa and Ottoman rabbinic sources?
Well, that's a good question. I would not be able to answer the question because I didn't look at the Ottoman, how the Ottomans responded to those cases. That will be a completely different research, maybe for the future, to look into the Ottoman archives.
Okay. Let's see this. Here's another one that I think is also very interesting, talking about the migration of Iberian Jews, Spanish, and then, of course, Portuguese. So they have a similar experience in a way, but of course different. As we know, those who left in 1492, especially right to go to the Ottoman Empire, those who came after the 1497 forced conversion, right, decades, if not centuries later. In Amsterdam or Ottoman Empire, or as you know, was there any tension at all between the Portuguese Jews who returned or reverted and the Spanish Jews who had left after 1492? What was their relationship like in cities where they lived?
That's interesting. There's some literature that discusses that. I believe what's his name, Melamed. He wrote a book about Portuguese Sephardic communities in the Ottoman Empire. There are two. There's Avigdor Levi. Avigdor Levi is one historian, and the other one is surnamed Melamed. I think Abraham Melamed is the author of that book. Sephardic Jews in the Ottoman lands in the early modern period, and they both discuss how these communities that left the Iberian Peninsula and went and reestablished themselves in the Ottoman Empire, they didn't like each other so much. So we have communities that that have the same exact name that they had in, or the towns or the cities that came from Spain and Portugal. Those names are found then in the Ottoman Empire. So we have like Comunidad of Extremadura, Comunidad of Cádiz in the Ottoman Empire, and they didn't jive with each other because they had different liturgies, they had different halakha, different customs. But then what happens after the Shabbatai Sevi movement, Messianic frenzy, most of these communities start to converge with each other. And so by the third, fourth, fifth generation, we cannot talk about this tension anymore. All these communities kind of they converge with each other, and they started marrying with each other after 2 or 3 generations already.
Very, very fascinating. I think we have time for another couple questions. I want to go back myself to the age of emancipation, the late 18th century, early 19th century, something Michael alluded to, something I'll be continuing in next month's webinar, how these ideas influence the founders of the American Republic and enshrining religious liberty, especially meaningful right as we approach America's 250th birthday. You talked again about the curtailment of legal in rabbinic, right, of autonomy, of
Yeah.
jurisdiction, of decision making. To what extent, say, by Napoleon, and I think, of course, of the famous declaration by Clermont-Tonnerre and the French National Assembly, right, in 1791, right, to the Jews as a people, nothing. To Jews as individuals, everything, right? To forcibly integrate them, right? Wrench them into kind of modernity and abolish that autonomous status they had. So, to what extent did the rabbis themselves or Jewish leadership themselves limit their say greater jurisdiction, or was it at all imposed just from external authority?
That's a very good question. I can say in the case of Amsterdam, we see that this responsa literature that has 12 volumes from the 17th century to the early 19th century, what happens is because now all these cases, which were then before brought to the Bet Din of the community, now they're no longer brought to the Bet Din. They're going to the local courts. So that is the end of the rabbinic jurisdiction on civil matters of within the Jewish community. So Jews now are members or citizens just like any non-Jew, and they go before the civil courts just like any non-Jew does. And so that means that the rabbinic establishment in terms of civil laws, so we talk about Shulchan Aruch, that's what these books are back here. We have Eben HaEzer and Choshen HaMishpat, which talk about family law, and then civil law. They become secondary or even obsolete in many places. And so this brings enters into an interesting discussion with what Ashkenazi Jews and Sephardic Jews are doing from then on, because what we see, this is part of what happens with the Orthodoxy. The Orthodoxy wants to preserve that rabbinic authority and that kind of culture of that identity. And Sephardic Jews integrate into modernity and then preserve the ritual, ceremonial aspects of Sephardic halakha and culture, and pretty much they look at it as something of the past. And so we have now all these archives, all these texts and responsa to be able to look into that history of what Sephardic Jews were doing before the emancipation.
You know, going off of that too, in any of your research, have you come across how, you know, again, we talk about the American experiment is different in a way than the European history. Anti-Semitism is there, it's of a different kind. Did the American experiment at all, is there discussion of that in any archives or records in the Amsterdam Jewish community or Portuguese Jews in the Ottoman Empire that you know of at that time?
Discussions of what exactly?
Just that how Jews are seen as different, or Jews are accepted or more integrated. Certainly from a Sephardic perspective, as you just said, to integrate more seamlessly into modernity. I mean, is there any connection? Is there any mention at all of what is happening in the United States in early America?
I believe so. There's a lot of literature in that context. There's a book that speaks about this. It's not very academic. It's called The Grandees, and it's like partly fictional, partly factual. But I think that book gives a good overview of the Sephardic ethos in the American context, the North American context. And it's all about integration. Sephardic Jews are integrating as much as possible into the American culture, whether it's business, trade, everything, in every aspect. And the only difference between a Sephardic Jew and a non-Jew in the general populace is religion, belief.
Yeah.
And so that's what I see that's happening in the North American context.
Well, utterly fascinating. And I think that's a great place to segue to invite everyone to join us next month for a talk on how this legacy continued to influence the American experiment, the founders, early Sephardic and Jewish communities, again, in ways that we are heirs of, we are beneficiaries of, and that will continue for sure to influence
I
generations.
would just like to add to this is that wherever I've seen, maybe perhaps I would like to write about this in my future publications, is that wherever Sephardic Jews are going in the New World's context, Caribbean, South America, North America, Sephardic Jews are fighting for freedom of religion and conscience. And they are putting their money to pay for war, for soldiers, ammunition. They are in contact with the political leaders of all of these different places. We see in the case of Rabbi Gershom Mendes Seixas in New Amsterdam or New York. We see the case of Mordechai Ricardo with Simón de Bolívar in South America. We see in the case of Jamaica, between Jamaica and Dominican Republic, David Leon Levy with Pablo Duarte in Dominican Republic. So Jews are behind independence and freedom. This is, and specifically Sephardic Jews are doing this. And I believe this is because of the suffering that our ancestors went through in the Inquisition and the expulsion. So this is our way of being a light to the nations.
Indeed, and I would completely agree with that. Thank you again, Hacham Dr. Elazar Demota, for this fascinating presentation on the story of the Nação in the Ottoman Empire and Amsterdam and how these communities rebuilt, restructured Jewish life after centuries of persecution. Thank you to everyone who joined us and has contributed such thoughtful questions. It's been an honor moderating this conversation, and I turn it back to Michael for closing remarks.
So, first and foremost, what an amazing closing statement by Dr. Jonathan. That's really, really powerful. So in closing, once again, I would like to thank our presenter, Dr. Jonathan Mota, for an amazing presentation. And of course, you, Dr. Ramon, for the excellent management of this program. Also, I would like to thank you, our audience, for your continued interest in the Saga of Sfarad and for putting up with us today. Thank you so much. We invite you all to join us November 16th for the final part of this series, which will be brought to you by Dr. Isaac Amon, as he explores how the Sephardic exile and resilience influenced early America and inspired the principles of religious liberty. Very, very interesting. Please come back for that. For any additional information about our work or upcoming programs, please sign up to our newsletter. Those interested in any of our tours, please get in touch. And at this time, we thank you again and see you next time. Bye-bye.
Bye-bye.